Well, good morning and welcome to Live Impact News here on 13 News Now. We come to you with a special report today on breaking news that we have just gotten across our desk from the Richneck Elementary School criminal trial. Day 4 was just beginning when it appears to have ended rather abruptly, and so we have a seismic update from Madison Schlegel, who has been covering this case from the very beginning. We just saw Ebony Parker walking out of court live, and now we go live to that very same parking lot where Madison Schlegel has an update for us on what has occurred this morning. Madison, what's going on?
Connor, the words out of Judge Robinson's mouth this morning is that there is no precedent for the case that was heard or presented in front of the jury this week. And the judge has ultimately decided to grant a motion by the defense and strike all 8 counts against Ebony Parker. The second that decision was made, we saw Parker audibly gasp and burst into tears. Basically, what the judge has kind of ruled in this case is that the jury is the trier of fact, and the judge answers the questions of law. And in this case directly, there was too many questions surrounding the indictment and what the actual indecent liberties that happened to the children, or what that reckless disregard for life truly was. So Judge Robinson did lay out a couple of the questions that she had. Again, those 8 counts were for reckless disregard or wanton abandon, for child neglect, in disregard for human life. And the judge basically said that she was unclear about what that disregard for life was. Was that the fact that the student wasn't expelled after the first incident that was recorded? Was it the fact that there were 8 still bullets in the gun? Was it the fact that there was emotional trauma for the children that were inside the room? Was it that there was a lack of response from leaders here? So the judge said, since there were so many questions surrounding the indictments itself and what was actually that disregard for life, she said that this case had to be stricken due to logistics when it comes to the law. Now, again, the judge did also say that this indictment didn't express exact people, but what it did do was kind of present a mashup of legal theories. So again, over the last couple days, you remember that there have been conversations back in court about hearsay, what has been striked from the record. And it was very contentious inside court with the conversations that were happening during testimony, because again, there were so many kind of blurred lines at which could actually be said in the court at this time. And the judge reflecting that sentiment in her statements today to us. But again, ultimately, this case that we've been following now for 3 years for Ebony Parker, I could only imagine that this is a weight lifted off of her shoulder. Our crews just spoke with her minutes ago. She didn't want to go on camera, but she did say that she is just so grateful and thankful right now for the judge's decisions. Now, as it comes to the other cases we did here today, the defense's excuse there in order to strike all these counts was the fact that these kids weren't directly named and that there weren't direct instances to make that wanton or disregard for life true. So again, breaking news that just came out of the courtroom just moments ago, less than 20 minutes ago, the judge made this decision. Right now, the court is in recess because the jury was supposed to show up at 10 this morning for their assignment. The judge has now decided that the court will go into recess until all the jurors have arrived today, and then Ebony Parker has been excused, but the attorneys will now stay behind, and the jury will be formally told about this decision under oath and on the record, and then they will be dismissed by the judge. So again, we thought that today the case might wrap up. We didn't know that this was going to be the end result of what happened today, but this decision definitely came down a little bit quicker than maybe some were thinking. But Connor, back to you.
Yeah, it certainly did, Madison. Going into day 4, every indication was that things would proceed as they have for the last couple days. You were supposed to do a 10 a.m. live hit just to give us a brief update on where things were headed, and instead you come to us with this massive piece of breaking news. The judge has struck all 8 counts that were alleged against Ebony Parker. Now, I want to get a sense from you now, and you did mention our other crew. Brianna Fallon is standing by. She was there when Ebony Parker exited the courtroom. We will will speak to Brianna live on air here in just a moment, but I want to keep Madison with us here first. Madison, can you give us a sense, once again, of how the courtroom reacted to this news? There have been moments during this trial where it has been crowded. I know it was early today. Anything you can tell us about the reaction to such a shocking revelation from the judge?
Honestly, Connor, when the defense made their motion this morning and then the prosecution laid out their arguments against it, and then we heard the defense's rebuttal, it truly seemed like it was up in the air on what Judge Robinson was going to decide. But the moment that she opened her mouth and started laying out some of the reasoning before she actually announced her decision, you could hear a pin drop inside of the courtroom. The second that the judge was alluding to the fact that she might be throwing out these charges was the second that we instantly saw that emotion come from Ebony Parker, and the room kind of shifted itself into this state of silence, on this state of waiting on the edge of your seat to kind of hear exactly where the judge was going to go with her statement. But the sentiments in which she was saying were pointing to the fact that she was going to point to legalities in the case that would potentially throw the case out. And again, once that decision was made, it felt like a sigh of relief in the courtroom for at least Ebony Parker and the people who have been in the courtroom this last week in order to support her. We did see some of those people that were in the stands watching, supporting Ebony Parker. They did throw their arms around each other in that moment. They did turn to each other and cry in each other's shoulders. Again, this has been a case that's been following around Ebony Parker and her family and her camp for the last 3 years. So I'm sure the emotions that they're experiencing are extremely heightened, and every single person in the room was just waiting on the edge of their seat for the judge to make that decision. But again, she had uttered the words, "There is no precedent for this case." We've said time and time again how this case was going to be historic, and those words came directly from the judge today.
Yeah, and this is an event and a case that has in many ways lacked precedent, and that continues on through the trial. Now, my next question may be based around some recency bias here, but it seems as though confusion and questions have really been a standout theme of this trial from the very beginning. There have been questions from jurors, questions from the judge, questions from lawyers about the jurors' state of mind. I mean, it really feels like there has been an air of confusion throughout. Is that a fair assessment? Is that something that you saw, and anything to add to that?
Yeah, and that was ultimately why Judge Robinson made the decision that she did make today. That was because she said there were too many questions of legal matters inside the indictment and with what was being presented by both cases, that it was just providing so much chaos for the jury that they were kind of left in a spot where they weren't really able to discern what was just exact fact versus what it was that they were truly trying to describe as that wanton or disregard for life. I keep mentioning that statement, but we do know that the prosecution's job was to prove beyond a doubt that the disregard for life was there. And as the judge had mentioned, there was just so many questions about what that exact disregard for life was that she wasn't going to put it in the jury's hands in order to make that decision. Again, the jury is just the trier of fact, so they're only able to assess the evidence and the information that is given to them by the prosecution and the defense. They're not the ones that are supposed to be hashing out what it means as to the exact statute at which they're supposed to be trying to defend. That is up to the backpacking of the judge, and that is why she made this decision today. She said that given the confusion that the jurors have already had in the past, that confusion was most likely to persist through the day today, and so she made that executive decision. I'm the one that's supposed to be the expert on the law here. My expert opinion on the law is that this just isn't clear enough.
And then another aspect that I want to ask you about that you mentioned in your initial report here is, and something we saw quite a bit yesterday and even the day before, but I felt like especially yesterday, was the emotional trauma for the other children inside the classroom and inside the school. What role did that play in the trial up to this point, and then ultimately this decision?
Yeah. Thinking about the testimony that was given yesterday by those parents, you can see that there are going to be lasting impacts to these children for, if not the rest of their life, for at least the future that they're experiencing right now. It's been 3 years, and we heard that many of those children are still in therapy or counseling today. What the defense was arguing was that there wasn't an exact list of 8 children. You remember there are 8 counts. The defense said that the 8 counts weren't specific enough when it came to naming exact children, when it came to naming exact ages of children. And then the prosecution had argued, well, we want to remind you, first things first, the 8 counts were for the 8 bullets that were inside of the gun, not 8 students that were mentioned. But in the opening statements from prosecution, they did mention the 20 kids that were inside of Abby Zwerner's classroom that day, that 20, including the 6-year-old child, JT. And since their case was based on the fact that the disregard for life was the trauma that these kids were going to experience, again, what's said in opening statements can't be viewed as to the jury as fact. So it was the prosecution's job to prove that in evidence. That's why they brought the parents of those students to come speak with the jurors and speak and give testimony. And again, the judge said that in answering, even though we did hear some of those traumas, the exact pinpoint of where that exact disregard for life just wasn't pinpointed enough for that trauma to truly be the emphasis in which the basis of those 8 counts stood on.
Okay, and last question for you, Madison, before we get to Brianna Fallon here is, I know we're right in the middle of this. This just happened. We have a tendency to look forward before we fully reckoned with the moment as it stands, but we do want to ask, what's next? Do we know what's next? What does the future hold when it comes to this case?
Yeah, so up next, again, like I told you, court's in recess right now until the jury can formally come back in and be dismissed by the judge. But moving forward, what we have learned across yesterday and also a little bit of today was that there are civil cases that are now pending by those parents of the children who were inside of Abby Zwerner's classroom. I'm sure that legality will now start to move forward, and we might start to see some movement in the case. But again, during those testimonies from those parents, they said that they didn't really want to divulge much information into those civil cases. But the defense did question of whether or not they had something to gain from a possible prosecution in this, from a possible conviction in this case, and that all of which the parents said, no, we don't have a direct positive gain from a conviction in this case. We just want justice for our children.
Okay, Madison Schlegel, incredible work all week long. That carries on into today. I'm sure that we will see you plenty today, but for now, thanks so much for this update. We'll talk to you again soon, and great work out there.
Thank you.
Okay, we're going to go to Brianna Fallon now. Brianna was outside the courthouse when Ebony Parker exited following the tossing of those 8 counts against her. Brianna, thank you for joining us. Appreciate your patience and just a summary of what you saw from Ebony Parker as she exited the courthouse.
So as soon as the judge granted that motion to strike, Ebony Parker, she just was ecstatic. You can hear cries in the courtroom this moment the judge made that decision. And leading up to those moments, she walked out. We did speak upstairs inside the courthouse. I just asked her, what's next for her, essentially, now that this case was essentially thrown out, struck down. What's next? She said right now she wants to move on with her life. Her family declined to comment any further than that, but she said she is very happy. She was in tears, very ecstatic. Then we came downstairs. We did follow her as she walked out of the courthouse, asked her a few more questions. She didn't really have much else to say besides, again, that she's just ready to move on with her life and put this behind her. But it was a very interesting day in court. Both defense and the prosecutors kind of went over why they believed this case should be stricken and why it should not. Again, ultimately, the judge did decide to strike it. Right now, we're still waiting outside the courtroom to hear from those attorneys. I did reach out to the Hampton Commonwealth's attorney because, again, the Hampton Commonwealth's attorney's office is prosecuting this case. I reached out for a statement, still waiting to hear back. But again, we are hoping to hear more reaction from those attorneys soon.
Speaking of the judge, and after she heard the arguments and delivered her decision, are you able to give us maybe a little bit more context around what that was like. Did the judge seem relieved, frustrated, anything about her sort of emotional disposition as she delivered this decision?
Yeah, after defense, put this motion up on the table, the judge kind of said that this could have been brought up yesterday, which was interesting. But I feel like a lot of why the judge decided to strike all 8 counts of these felony charges, it was just a lot of confusion just around what the charges were for. She mentioned, were the 8 charges because of the 8 bullets in the gun? Was it because of the 8 children in the classroom? So she was kind of talking about how a lot of this was theoretical and there wasn't any concrete evidence necessarily that a crime was committed, Connor.
Okay, and I briefly want to go back to Ebony Parker, Dr. Ebony Parker. She exited the courtroom, straight to the car, and I'm assuming left the premises. In terms of family around her, did she have a large group of people with her? Was she accompanied by an entire family, a team? I'd love to know more about sort of her general reaction and the reaction of those around her.
Yeah, she did have a lot of family here today. They were kind of standing outside of the courtroom waiting for her to come out after that ruling came down. She came out, ran straight to one of her family members, and they just hugged for quite some time. They were crying, just again, very, very emotional with everything happening. They came out with her. I did hear them mention that she wished that her sister was here today. But again, she was surrounded by a lot of family today. A lot of family showed up to support her today. Now, again, while they didn't want to comment, they did say that at this point they just want to put everything behind them and just move on now that the trial was struck.
I can only imagine. I mean, it has been 3+ long years, I'm sure, through the course of this process. We saw Dr. Ebony Parker, a Zoom call she had with an HR representative was played in court yesterday. We saw emotion from Dr. Ebony Parker just even in that Zoom call. In terms of what you're seeing right now around court, is there any sort of crowd left? Has this kind of, it has come and gone, such a seismic decision, and now it's on to sort of a regular day as usual in Newport News? Is there anything lingering that you can tell us about?
Yeah, I mean, again, as soon as Parker exited the courthouse with her family, they went straight over to their car. They tried to get out quickly because, again, like she was saying, she's very, very happy about this ruling, but she does want to move forward. As for what's lingering right now, we are still waiting for attorneys to come out. We're hoping to speak with prosecutors with the Hampton Commonwealth's Attorney's Office to just hear further comment and reaction about, now that this happened, now that the judge struck all 8 felony counts here today, what's next, essentially. So we're still waiting for them to exit the building, and we're, again, hoping to get more reaction for them a little bit later today.
Okay, Brianna Fallon outside the courthouse in Newport News. I'm sure we'll see you again before the day is over. For the time being, we appreciate it, Brianna. And you heard from Brianna there as she talked about sort of the reaction, cries in the courtroom after this decision was made by the judge in Newport News. I'm going to bring on our producer here now, Samantha Spinacci, who is in studio with me. Samantha, we have a look into the courtroom in Newport News, presumably on the 30-minute delay that we've been working with. Sometimes with Live Impact News, you kind of have to discuss and make decisions over the airwaves, such as the nature of a live stream. I'm wondering, is this something that we know that we can listen in on now?
I don't know if there's audio on it, but we definitely have a video source. We can try it.
Okay, let's try it. I'm wondering, with that 30-minute delay, if this will be an opportunity to hear the judge read the decision that we've now heard so much analysis of from our reporters. Let's take a listen into that courtroom from earlier this morning as this seismic piece of breaking news was presumably read by the judge. Let's take a listen.
Are we ready to call the case of Commonwealth versus Parker? We are. And to the media personnel, the buttons that we have to press to turn on the audio are all in place? Okay, thank you. All right, so we are calling the case of Commonwealth versus Parker. For the record, let it reflect the Commonwealth attorney is present, Mr. Jenkins, with Ms. May. Good morning to you both.
Good morning.
The defense is present, Mr. Rogers and Mr. T. Good morning to you both.
Good morning.
The defendant is present, Ms. Parker. Good morning to you both. We rested yesterday. Is there anything you need to address this morning?
Yes, Your Honor, I have two matters.
Okay, yes, sir.
The first is that the court yesterday, as I understood it, we agreed to admit the full and unredacted interview between Dr. Parrish and Dr. Parker. I needed time to just place that on a USB drive. I have done that. It's on Madam Clerk's counter there. I understood at the time that the court had admitted it, and I just needed to provide it. But if the court had not admitted it at that time, I am moving to reopen and admit it as Commonwealth 6.
Any objection?
Not any objection to reopening for the purpose of admitting that.
That's it.
Okay, so granted, Commonwealth is reopened, and we will admit it. Does Madam Clerk have it now?
Yes, it's
Okay.
right there.
All right, and this would be 6, Madam Clerk?
Yes, ma'am.
Okay, so admitted, and again, this is just the full video of what's already a redacted version in evidence. Okay, and now that that's done, do you rest again, Mr. Jenkins?
Yes, we rest the reopened case, yes.
Okay, and the second matter?
Second matter, Judge, is just as a preliminary matter, I understand that the defense, pursuant to their own subpoenas, intends to call as their witness several witnesses that have already testified, including Ms. Zwerner, Ms. Kovac, Ms. Parrish, Ms. West, perhaps others. And I just want, as a preliminary matter, to point out Jones v. Commonwealth 2023 VA Act, Lexus 294, decided May 16th of 2023, which holds that it is not proper for the defense to do any impeachment when it calls its own witnesses. And so I am asking the court to instruct the defense not to do any impeachment and not to recross on matters that they already had a full opportunity to cross on. But I certainly would not object to them eliciting new evidence in their client's favor from those witnesses. But in terms of recrossing witnesses they've already crossed, that would not be proper. They're here pursuant to the defense subpoena. So I wanted to raise that issue.
Yes, sir, thank you. Response?
Yes, Your Honor. We would be asking, in the event of calling these witnesses, that they be, that we be able to examine them as hostile witnesses.
And so ultimately, we will cross that bridge when we get to it. You all are entitled to call whatever witnesses you wish, and if they meet the qualifications to be declared hostile or adverse and be treated accordingly by impeaching and or leading questions, then if they meet that statutory criteria, then that will be allowed. So Mr. Jenkins, I understand your objection now, and it'll be ongoing, and when we get there, we will address it. But again, if they meet the criteria for being a hostile witness, the court will allow them to be treated as such.
I understand. Thank you.
All right, thank you. Okay, so with the Commonwealth resting, defense asked to prepare, time to prepare their motions to strike, and we'll start with them this morning. Are we ready for that?
Yes, Your Honor.
Okay, I'm ready. Please proceed.
Your Honor, the Commonwealth has filed 8 indictments for felony abuse and neglect of children. I am going to just sort of assume that the Commonwealth is proceeding under the fact that there were at least 8 children that were abused and neglected on January 6th. Your Honor, if that's the case, I would say the Commonwealth hasn't established that there were 8 children present in the classroom on that day when this incident occurred. The Commonwealth definitely hasn't established 8 separate incidents. So we have one incident where I guess potentially the Commonwealth believes that there was 8 children present. But the Commonwealth did not present the names of 8 individual children that were in class that day. They presented no roster or role that was confirmed by any employee that was on staff that day. And more importantly, the Commonwealth is required, I'll just read the jury instructions. In this charge of the crime of child abuse and neglect, the Commonwealth must prove beyond reasonable doubt due to the following elements of evidence. And I know that at this point where it's likely extendable to the defendant was a parent, guardian, or other person responsible for the care of whoever these children are, these unnamed children, and that these unnamed children, this unnamed child or children are or were under the age of 18. There was no testimony that any individual child that was present in the classroom by name was under the age of 18. Also, the Commonwealth has to prove that the defendant's willful act or omission in care of whoever these unnamed children are was so gross, wanton, and culpable to show a reckless disregard for human life. Jury instruction that discusses the definition of willful says, a willful act is one done with a bad purpose or without justifiable excuse or without ground for believing it is lawful. A willful act is intentional or knowing or voluntarily as distinguished from accidental. The terms bad purpose or without justifiable excuse require knowledge that a particular conduct would likely result in injury or illegality. Your Honor, in my own words, the Commonwealth has to establish that Dr. Parker knew, and her response was, so what? I know that there is a weapon and that there's a likelihood that children will be harmed by that weapon or firearm, and I don't care. Let whatever happen is going to happen. There was no evidence that was Dr. Parker's response to anything that happened on that day. She was brought limited information, and she responded to the information that she had. Again, I asserted at the very beginning of this, if we look at the behavior of everyone that had contact with JT on that day, they did not believe that there was a firearm. They did not believe that there was a weapon. There was testimony from Ms. Zwerner. She was the person that had the most direct contact than anyone on that day. Her behavior did not indicate that she believed that there was a weapon. She left JT in the classroom. She left other children in the classroom. Then we go to Ms. Kovac. Again, she sat with him, had her eyes on him, watched his behavior. She said it was weird, but her actions in no way indicated that she believed that there was a firearm in possession of JT. And then we consider what Mrs. West testified. She said there were some concerns. She actually observed JT on the playground with the other children. Based on her observations, she was satisfied that there was no weapon. And she only became concerned again when there was a report almost contemporaneously with the shooting that there in fact was a weapon. And then we consider the testimony of Mr. Rawls. He had a lot of contact with JT leading up to this event. On the day of the event, concerns were brought to him. He investigated, put his eyes on JT, was satisfied that JT did not present a danger of harm to the students in the classroom. Your Honor, based on the information that Dr. Parker had, she made decisions. In hindsight, those decisions actually were determined not to be the correct decisions. But that wasn't her decision wasn't an act of neglect. There was no bad purpose, obviously. She didn't intend any harm to the students. Without justifiable excuse, Your Honor, based on the information she had, she took actions that she believed were appropriate based on circumstances. And so there was no bad purpose. There's really no excuse that we're trying to say other than she did not believe that there was a weapon, so that explains her conduct on that day. So there was no information that she had that she came to the conclusion that was going to lead to harm to her students. And after coming to that conclusion, she decided that she didn't care. So what? I'm going to leave that threat of harm to those students because of JT having a firearm. The Commonwealth hasn't met its burden to establish a willful act. The Commonwealth has not established the specific names of children and their ages that were present in that classroom. We asked to consider striking the Commonwealth's case.
Thank you, sir.
As big as
Okay,
this
we
one.
come out of the courthouse because we have one of the lawyers now speaking to Breonna Fallon outside of the courthouse itself. We're going to go live to that sound right now.
Often, yeah.
Yeah.
Well, that's common.
Have you ever seen it before in one of your cases?
No, not on a felony, no. Yeah.
And this was 8 counts, right? I mean, that's
counts.
pretty significant. Can you talk a little bit about that and kind of coming to that conclusion to put that defense together to get the judge to strike this?
Well, Curtis Rogers was the lead attorney on this matter. I came in to assist him. I'm happy that I was able to help him, but this is his case, and he prepared diligently, and I'm proud of him, and I'm happy for Dr. Parker.
Judge Robinson said she had no precedent to work with. Is this a landmark case and a landmark ruling?
I believe it will be, yes.
Yeah.
Thank you all.
Thanks.
Thank you.
Okay, brief but impactful out there, a landmark case and a landmark ruling from one of the lawyers assisting in the defense. Let's go back into the courtroom now. What we're listening to in this courtroom is a 30-minute delay of what we have had our reporters analyzing and breaking down and updating us on over the course of the beginning of this show. We are now hearing the arguments for and against that motion that was brought this morning, and ultimately we will hear from the judge as she makes her decision to strike those 8 counts. So let's go back into the courtroom on a 30-minute delay. We'll be able to watch as they go through the proceedings that led to the landmark decision that you heard one of those defense attorneys just speak about outside the court. We'll continue to monitor our cameras and our reporters outside the court in case there is more up-to-the-minute live sound. For now, back into the courtroom.
Up to the number of victims that they believe existed in this case with a maximum of 8. And certainly no indictment can be returned twice for the same victim, and that can be explained to them. But at the end of the day, the jury is the fact finder, and they can decide whether what number of victims there were, if any. And so we think it is inappropriate to try to narrow that to specific names, but rather that the jury can decide based upon the evidence that they have how many to return or to return none. How many to find guilty on or to find not guilty on all. Given that the argument generally being we didn't prove there were victims, I think that's definitely false. Specific children were referred to, 5 of them by my count, R, S, D, GG, MG, and KS were the specific children that we referred to during the course of the trial.
Ms. Jenkins, if you go with the initials one more time, I have S, D, GG, MG,
KS, and RR.
Thank you.
So we have a total of 5 children that we identified with specificity, but I'll point to the testimony of Ms. Zwerner, who said there were about 20 students in her classroom, many of whom were in her field of vision at the moment that she was shot, and I would propose that it is up to the jury whether they believe more or fewer victims exist of this crime, and so we believe we should not be required to name specific victims in either the instructions or the indictments. The argument that we did not prove age begins with a reminder of two things, and of course the court is aware, the burden of proof at this stage is the light most favorable to the Commonwealth, but I think more importantly, that circumstantial evidence is evidence. Had testimony from several parents who said that they dropped their first grader off at school, that their child was in first grade, and that they were in Ms. Zwerner's class. Ms. Zwerner testified that first graders are about 6 years old. And throughout this trial, we've instructed witnesses on the record to refer to people under the age of 18 using initials, and you've had several parents come in and testify using only initials of their own children. The overwhelming evidence then is that these children were under the age of 18. No, we don't have all of their specific ages, but they were first graders in Ms. Zwerner's class, and they were students attending an elementary school. And so I think that the proof of age has been sufficient to survive the motion to strike. There were two legal standards mentioned by defense counsel in his argument to the court. And one was that he indicated that we had failed to prove that the defendant knew of the danger. But if you consult the model jury instructions, that is not the standard. The model jury instruction for criminal negligence tells us that to constitute criminal negligence, the Commonwealth must show that the defendant either knew or should have known that the probable result of his or her acts or omissions would be serious injury or death to a child. Given that, the correct standard for the court to apply is not that Dr. Parker knew there was a danger necessarily, but that she should have known of the danger. Having said that, she did know. There were multiple warnings she received from multiple people that there was an armed student. And as I argued during the trial on several objections, whether they thought it was a toy, whether they thought it was a knife, whether they thought just the mere fact that a possible weapon is on campus should have triggered the response defined in the crisis management plan, yet it did not. So it should have known and not known. The second legal standard defense counsel left out is from the willful act definition jury instruction. And so the model on that says a willful act is done with bad purpose. That's what defense counsel pointed out, but it's with bad purpose or without justifiable excuse. And I would argue that that is the part that we rely on here. I do not argue that Dr. Parker had a bad purpose. I will concede that fact. But the law says it's either of those, a bad purpose or without justifiable excuse. And I certainly do believe the evidence has shown that she willfully omitted acts that she should have done, and that she had no justifiable excuse for that willful omission. Given that, Judge, I ask you to deny the motions to strike.
Thank you, sir. This is the defense motion, so they can have the last word. Anything additional?
I just want the court to keep in the forefront, again, the actions of everybody. Nobody acted as if there was a actual firearm. Not following school policy doesn't result in a criminal allegation. There were acts that should have been done, definitely in hindsight, but based upon the information that Dr. Parker had, she did not willfully take any action, or there was no willful omission on her part to put these children in harm. Again, mistakes occurred, but there was definitely no criminal intent, and I would submit that her actions in the end were not criminal. It was just that at the most it was a lapse of judgment. Somebody makes makes a mistake, that should not result in felony allegations or definitely felony convictions. So omitting a step in a school policy should not be considered to be a crime. She acted upon the information that she had. She took the steps that she thought were necessary. She did not believe that there was a gun. Nobody that was there acted as if they believed that there was a gun. And I'd ask that you find the Commonwealth, even at this stage, and like most people to the Commonwealth, has not established a willful act or omission. And definitely the Commonwealth, I believe, is conceding that there has been no specific proof of the age of any child that was in the classroom.
Anything further before the court makes a rule on the motion to strike?
No, Your Honor.
I will be honest, we could have done that yesterday. I expected more substantial motion with case law and additional principles of law that the court would probably need to recess and consider, but we are where we are. Having considered this case for 4 days and listened to the motions of counsel, and the division of labor in a criminal jury trial. So in that division of labor, in those legal proceedings, questions of facts go to the jury, questions of law go to the judge. A question of fact asks what happened, and it requires evaluating evidence, such as the witness testimony and or physical proof. Questions of law ask how does the law apply to those facts, and requires interpretation of statutes, precedents, and constitutional rules. And that's kind of legalese, but breaking it down. The judge decides the question of law, which is what law applies, procedure, and runs the courtroom. In this case, a criminal jury, the jury would decide the facts, which is what happened. To give an analogy, because this case doesn't put itself well to analogy, somebody is given a ticket for speeding 70 and a 65, but they're stopped in a parking lot. The jury decides the question of fact. Was that driver actually going 70? The judge would decide, does the speeding law apply in the parking lot? So that's the way to wrap your mind around the difference between question of law and fact, which can get quite convoluted. With the question of fact being resolved by the trier of fact, which in this case is the jury, and their job would be to weigh the strength of the evidence and the credibility of the witness, and judges resolve the questions of law. And what would be put to the jury in this case was whether or not Ebony Parker is guilty, and that would be the question of fact. I do say all this because the distinction between law and fact can become convoluted, and they can be mixed. It can be a mixed question of law and fact. The Supreme Court itself has acknowledged that it can be an imperfect science of where is that dividing line, but identifying that line is important, critically important, whether or not it's a question of law or fact. Question of fact goes to the jury, they make the decisions. Question of law, it stays with the judge. And I guess for purposes of the party's understanding, that influences the courtroom decision maker, the appellate review, how evidentiary rules are administered, and the application of precedent, which I would say there is no precedent for what's before the court of an administrator being criminally charged and tried for what has been presented and what happened that day, January 6, 2023, at Richneck Elementary School in Newport-News. This court is finding that it is presented with a question of law, which requires resolution by the decision maker. The decision maker on questions of law are the judge, and whose decision is that, and my decision is that this is a matter for the court, and the court is of the legal opinion that this is not a crime, not under the common law of Virginia, nor under the code of Virginia. And the court is going to explain its rationale and ruling. With that being said, if it's not a crime under the common law, nor under the code of Virginia, should the legislature wish to make this a crime, then they will create specific statutory language to do so. When reviewing the statutory language, the court is bound by the plain meaning of that language and must give effect to the legislature's intention.
Okay, we are back here on Live Impact News in the studio, and you can see on your screen as the judge was reading her decision, Ebony Parker reacting there in the courtroom. You saw her sort of put her head down onto the table in front of her as the judge is, again, eliciting that decision to strike all 8 counts charged to Ebony Parker in this case. And again, one of the very first things that Madison Schlegel told us this morning, that phrase, no precedent for this. You heard it there from the judge in that very specific moment as we got to hear sort of a real-time accounting of what we were updated on by our reporters. Judge Rebecca Robinson making that decision there in the courtroom and the court reacting. Now, we are going to bring Madison Schlegel back onto the program here with more updates for us as news continues to roll in. Really, reaction continues to roll in to this seismic decision that we've seen this morning. Hello again, Madison. What updates do you have for us?
Yeah, Connor, obviously you just heard those words there from Judge Rebecca Robinson about the decision that she made in this case. You had mentioned Ebony Parker's reaction and how she was when that decision was made. But ultimately today we're also hearing from the attorneys of Abby Zwerner. Not even 15 minutes ago, I have received a statement from her attorneys on Abby Zwerner's behalf. I'm going to read you a little bit of this statement here. So mind you, these next words that I'm going to say here for a little bit are coming from the mouths of the attorneys of Abby Zwerner. So their statement reads as follows. One of the many obstacles the city of Newport-News placed in Abby Zwerner's path to justice was their argument that they could deny insurance coverage in our civil case because of possible criminal conduct. Today, that's no longer an excuse that the city can hide behind. This was always the Commonwealth's criminal case, not Abby's civil case. Abby complied with the subpoena requiring her testimony once again, despite the emotional toll of repeatedly reliving this tragedy. From the beginning, our focus has remained on obtaining justice in the civil court for the preventable failures that led to Abby being shot. A Newport News jury has already spoken, returning a $10 million verdict in Abby's favor that was in the civil case, remind you. The statement goes on, yet even today, the city of Newport News continues to resist accepting responsibility and delivering the justice that verdict represents. So again, those are words there from Abby Zwerner's attorneys. It kind of echoes the same sentiment that we heard after Abby testified on Tuesday. We spoke with her attorney, Diane Toscano, and Diane had told us that, again, this case was just another representation of the failure of support that Abby Zwerner saw on that day on January 6th, and this statement stands by that. Now, I don't feel that we're going to be hearing from Zwerner directly in this case. Obviously, throughout the last 3 years, in majority, in part, she's been speaking through her attorneys. So I have a feeling that this statement right here, those couple paragraphs that they sent us, is going to be the extent of what we hear from Zwerner's camp at this time. But again, those reactions are still rolling in. At the moment, we do have the 13 News Now legal analyst Ed Booth, who's on his way right here to Newport News to speak with us live to give us a little bit of an insight into the judge's thought process about this decision. Again, this decision was made on logistics of law, and Ed Booth, our legal analyst, will be here to help us sort through that conjecture to make sure that you at home can understand. Even just minutes ago, while you guys were listening to the judge's decision, I had a community member come up to me and say, hey, I've been following this case for years. I just heard the judge threw it out. Does that mean that Ebony Parker is innocent? And I said, No, what the judge ruled today was that the indictments that were brought forward by the prosecution were not outlined specifically enough, and it raised enough conjecture that it would raise confusion with the jury, and the judge did not want the jury to be making decisions on law. That was her job. And so the reason this case was thrown out was because of the multiple legal theories that this case was trying to use in order to prove that disregard for life. And she said it didn't reach that minimum. So again, people in the community here in Newport News are curious about this decision, wondering what that actually means and how it's going to move forward. But again, one of that star witnesses in this case, Abby Zwerner, who we learned today that the defense was possibly going to call back for questioning, has now made a statement on this issue. And again, her attorneys are highlighting what they say is a failure by the city of Newport News in order to claim responsibility about what happened to her on January 6th of 2023.
Okay, thank you so much, Madison. And an update for our viewers. On the screen next to Madison, you see our double boxes. On the screen is Ebony Parker in the courtroom. You see the emotion from her. You then see the emotion from others who were in the courtroom at the time. So what you're watching, again, is that 30-minute delay of the livest look that anyone has access to inside this courtroom. We just saw the judge read that decision, and now we're watching as both Ebony Parker reacts and as others in the courtroom, presumably who are connected to her, react. And you saw kind of the video, and you can see on your screen as the judge was reading her decision, Ebony Parker reacting there in the courtroom. You saw her sort of put her head down onto the table in front of her as the judge is, again, eliciting that decision to strike all 8 counts charged to Ebony Parker in this case. And again, one of the very first things that Madison Schlegel told us this morning, that phrase, no precedent for this. You heard it there from the judge in that very specific moment as we got to hear sort of a real-time accounting of what we were updated on by our reporters. Judge Rebecca Robinson making that decision there in the courtroom and the court reacting. Now, we are going to bring Madison Schlegel back onto the program here with more updates for us as news continues to roll in. Really, reaction continues to roll in to this seismic decision that we've seen this morning. Hello again, Madison. What updates do you have for us?
Yeah, Connor, obviously you just heard those words there from Judge Rebecca Robinson about the decision that she made in this case. You had mentioned Ebony Parker's reaction and how she was when that decision was made. But ultimately today we're also hearing from the attorneys of Abby Zwerner. Not even 15 minutes ago, I have received a statement from her attorneys on Abby Zwerner's behalf. I'm going to read you a little bit of this statement here. So mind you, these next words that I'm going to say here for a little bit are coming from the mouths of the attorneys of Abby Zwerner. So their statement reads as follows. One of the many obstacles the city of Newport News placed in Abby Zwerner's path to justice was their argument that they could deny insurance coverage in our civil case because of possible criminal conduct. Today, that's no longer an excuse that the city can hide behind. This was always the Commonwealth's criminal case, not Abby's civil case. Abby complied with the subpoena requiring her testimony once again, despite the emotional toll of repeatedly reliving this tragedy. From the beginning, our focus has remained on obtaining justice in the civil court for the preventable failures that led to Abby being shot. A Newport News jury has already spoken, returning a $10 million verdict in Abby's favor that was in the civil case, remind you. The statement goes on, yet even today, the city of Newport News continues to resist accepting responsibility and delivering the justice that verdict represents. So again, those are words there from Abby Zwerner's attorneys. It kind of echoes the same sentiment that we heard after Abby testified on Tuesday. We spoke with her attorney, Diane Toscano, and Diane had told us that, again, this case was just another representation of the failure of support that Abby Zwerner saw on that day on January 6th, and this statement stands by that. Now, I don't feel that we're going to be hearing from Zwerner directly in this case. Obviously, throughout the last 3 years, in majority, in part, she's been speaking through her attorneys. So I have a feeling that this statement right here, those couple paragraphs that they sent us, is going to be the extent of what we hear from Zwerner's camp at this time. But again, those reactions are still rolling in. At the moment, we do have the 13 News Now legal analyst Ed Booth, who's on his way right here to Newport News to speak with us live to give us a little bit of an insight into the judge's thought process about this decision. Again, this decision was made on logistics of law, and Ed Booth, our legal analyst, will be here to help us sort through that conjecture to make sure that you at home can understand. Even just minutes ago, while you guys were listening to the judge's decision, I had a community member come up to me and say, hey, I've been following this case for years. I just heard the judge threw it out. Does that mean that Ebony Parker is innocent? And I said, no, what the judge ruled today was that the indictments that were brought forward by the prosecution were not outlined specifically enough, and it raised enough conjecture that it would raise confusion with the jury, and the judge did not want the jury to be making decisions on law. That was her job. And so the reason this case was thrown out was because of the multiple legal theories that this case was trying to use in order to prove that disregard for life. And she said it didn't reach that minimum. So again, people in the community here in Newport News are curious about this decision, wondering what that actually means and how it's going to move forward. But again, one of that star witnesses in this case, Abby Zwerner, who we learned today that the defense was possibly going to call back for questioning, has now made a statement on this issue. And again, her attorneys are highlighting what they say is a failure by the city of Newport News in order to claim responsibility about what happened to her on January 6th of 2023.
Okay, thank you so much, Madison. And an update for our viewers. On the screen next to Madison, you see our double boxes. On the screen is Ebony Parker in the courtroom. You see the emotion from her. You then see the emotion from others who were in the courtroom at the time. So what you're watching, again, is that 30-minute delay of the livest look that anyone has access to inside this courtroom. We just saw the judge read that decision, and now we're watching as both Ebony Parker reacts and as others in the courtroom, presumably who are connected to her, react. And you saw kind of the just the emotion sort of pouring out there for a brief moment after hearing. Now you see the prosecuting attorney who seems to be speaking to the judge here. But we'll go back to Madison. Madison, you know, I want to touch on something from Abby Zwerner's statement that I found interesting. And I know we're going to have Ed Booth, who kind of has a more erudite understanding of some of the legal technicalities that go into this. But the opening of that statement actually took an interesting path, which was that there was no longer an argument that criminal conduct could deny insurance coverage for the $10 million that Abby Zwerner was awarded in her civil suit against Newport News Public Schools. Are you able to give more insight into that? Because that's a very interesting aspect of this, in that the throwing out of this case in some ways cleared obstacles towards her getting the amount of money that she won in that civil case.
Yeah, and Connor, we kind of heard a little bit of inklings of that yesterday when we heard from the parents of students who were inside that classroom when the defense was crossing them. Again, we learned about those multiple civil cases, well, the one civil case that's now being representing multiple of those parents. Again, the defense kept asking those parents, do you have something to gain from a conviction in this case? And again, they were hoping that a conviction, they were alluding to the fact that a conviction in this criminal case could help lend to the civil case. Now, you mentioned Abby Zwerner's civil case, which again is separate from the case that's being filed by parents of the children who were inside that classroom. And now, again, Abby Zwerner was originally seeking $40 million, and the court only came up with 10. So again, I'm going to leave the legal conjecture up to Ed Booth. That will be one of the first questions that I ask him here. How will what happened today impact the legalities of the funds that Abby Zwerner is expected to get from this instance and from the civil trial that she went through last year? But again, I think what you mentioned right there too in her statement, and was also echoed across the platform here, is that this reliving of trauma. Abby Zwerner opened herself up once again to be inside of a courtroom and talk about one of the most impactful days of her life, which has changed the trajectory of her life. And again, in seeing her testimony on Tuesday, you could see that reliving of memory happening in her head as she was giving her testimony. They asked her, Abby, what happened that day? And you could see the movie playing inside of her head. You could see it on her face. You could see it in her body language. And again, body language was a huge thing in this case. You spoke about it just now with Ebony Parker. Even though we haven't heard direct words from her other than she's grateful for this decision, the emotions on both sides of this case, whether that be from Zwerner, from Amy Kovac, the reading specialist, whether that be from Dr. Ebony Parker, again, the emotions across the board here run so deep. And now they're connected to legal funds in which, again, Abby Zwerner's owed that $10 million. So again, once Ed Booth gets out here, we'll sit down with him and we'll chat legalities of the situation, not just some explaining into what the judge has decided here, but also kind of what foreground this lays for those multiple civil trials going forward and how those funds will possibly be reimbursed.
Okay, Madison Schlegel, as always, we appreciate it, and I'm sure it won't be long before we see you again. Thanks for a little bit of time here as we move towards the 11 o'clock hour. And again, we await Madison Schlegel's analysis with our legal analyst, Ed Booth, who will be joining her shortly. Thanks, Madison. We appreciate it. Okay, now we move forward to Brianna Fallon, who is also there outside of the courthouse. She has now spoken to, or at least tried to speak to, lawyers from both sides, the defense and the prosecution, as they were exiting the courtroom. Brianna, what can you tell us about what you've seen over the last half hour?
Yeah, you know, we did try to speak to prosecutors. They kind of went over that they have no statement right there. Right now. I did ask them, though, what's next now that the judge kind of struck all 8 felony charges. He said right now that is all from him for the criminal proceeding, so it's unclear if there's going to be any further situations with this case. We also did speak with defense. They were very, very, very excited about this. They mentioned how at the end, once they realized that the judge was going to go in the direction that they went in, that it was just pure excitement. Pure relief was one of the words that they used, just that overall relief after 3 years of, sitting on this trial. The judge decided to strike all 8 felony counts. And he mentioned, he's not really sure what is next for Parker, but he's looking forward to seeing what happens.
Okay, so still...
What happened today with the case?
We believe that the correct outcome was reached, and we're thrilled for Dr. Parker. Thank you.
What was that moment like when the judge said this didn't constitute a crime, and then Dr. Parker started sobbing?
Right, yeah, it was just a relief for her, great relief for her, and we're just happy that we were part of her journey.
What's next for her?
I'm not sure, but thank you so much, everyone.
Yeah, and what was your just initial reaction, once you realized what direction the judge was going in?
Relief, happiness.
How often do you see a motion to strike succeed?
Well, I've never been at a part of a case as big as this one, but very often in misdemeanor cases, motions to strike succeed. In misdemeanor cases.
This wasn't a misdemeanor case.
Right. So,
okay.
But in felony cases, I think it's way less
right.
often. Yeah, way less common.
Have you ever
seen it before?
No, not on a felony. No. Yeah.
And this was 8 counts, right? I mean, that's pretty significant. Can you talk a little bit about that and kind of coming to that conclusion to put that defense together to get the judge to strike this?
Well, Curtis Rogers was the lead attorney on this matter. I came in to assist him. I'm happy that I was able to help him, but this is his case, and he prepared diligently, and I'm proud of him, and I'm happy for Dr. Parker.
Judge Robinson said she had no precedent to work with. Is this a landmark case and a landmark ruling?
I believe it will be, yes. Thank you all. Thank you.
Yeah, and that was the defense attorney kind of talking about the reaction to this case, again mentioning just that relief that was felt once the judge decided to strike these charges. He mentioned how this could be historic. He's not sure of many times when, 8 felony charges are dismissed like that. He said it's more common during misdemeanor trials. So again, just that pure relief that we saw from defense attorneys, the relief we saw from Parker as she exited the courtroom today. There was just a lot of emotions. She was surrounded by family. So again, a very relieving time for defense and for Parker. Connor.
Okay, Brianna, I am sure it is, and we really appreciate all of your hard work out there outside of the courthouse, chasing down lawyers, making sure we have all of that reaction and up-to-date information. We appreciate it, and we'll see you later on in the day.
See them.
Okay, so that was, again, Brianna Fallon speaking to one of those defense attorneys for Ebony Parker, and that certainly stands out, that the right at the end there, a landmark case and a landmark ruling. Stephen Teague said he believes that it will be, and it certainly feels that way at this moment in time. Once again, that sort of breaking news update for anyone who's joined us here recently. Judge Rebecca Robinson has struck all 8 counts charged to Dr. Ebony Parker in the Richneck Elementary School criminal trial. That is the breaking news of the day. Day 4 of the trial doesn't really get underway before the entire thing comes to a close. We've been hearing from Madison Schlegel and Brianna Fallon on the ground all morning. We appreciate all of their hard work. We appreciate all of you for staying with us as we sort of work out how the best way to bring you all of this up-to-date information as it comes into our newsroom. And no precedent. Again, another one of those statements that really stands out when it comes to what we've seen here today in this decision from the judge in this trial, and how, again, the jury is a trier of fact, and there were simply too many questions around the indictment at this time. And so after the motion that came this morning, the judge has decided to throw out all 8 counts, and for the time being, this event that we saw more than 3 years ago in January of 2023, January 6th, 2023, it closes another chapter. And as you heard there from both Brianna and Madison, what's next, we do not know. But for now, this trial is currently done. And our time with you here on ABC on 13 News Now is done. Our coverage, however, is not. We will be continuing our coverage on Live Impact News on the 13 News Now app. You can download it for free, and we are going to have our legal analyst, Ed Booth, on with Madison, giving us more insight, more in-depth understanding of the historical significance of this decision, of why the judge came to this decision, of what makes this case so unique. We are going to have all that coming up again on the 13 News Now app on Live Impact News, this very platform that you see here. But as for our time here on 13 News Now on ABC, we greatly appreciate everyone's patience. Thank you for staying with us. We hope to see you over on the app. If not, perhaps we'll see you at noon. For the time being, we appreciate everybody watching.